Hello, everyone. My name is Bill Skidmore. I'm on the board of directors of the Legal Center for Palestine. I'm a retired human rights and social justice professor from Carleton University in Ottawa, and I've had a long time interest in the Palestinian cause. I'm happy today to be joined for an interview, a conversation by Samrah Mian, who is a lawyer in Canada who, together with other lawyers, attempted to convince the Canadian Bar Association, of which they are members, to make a statement regarding international law and Palestine in light of the ongoing genocide taking place in the Gaza portion of Palestine. It's it's an interesting case as I've read it, not just why they're doing this, and we'll get into that, but the reaction, the stonewalling, the double standards that are involved by organizations that actually fight to stop such resolutions, not only from being passed, but even from being heard. So welcome, Samrah. We'll have a conversation about this. There's a lot to explain. One thing I'd like to just say to viewers of this, there will be links added into the YouTube description of key documents, which you'll be able to look at, such as the resolution that Samrah and her colleagues prepared for the CBA to be passed. So you'll have a sense of what it was they were arguing about. So welcome, and let's get going on this. You approached the CBA. You're a member, but why did you take a resolution to them? What's the importance of these kind of resolutions, and why these kind of what we call it overview bodies of professions?
Thanks so much, Bill. We wanted to bring something to the Canadian Bar Association because it's a voluntary association. The CBA, apparently at one point it was mandatory, but the National Canadian Bar Association is really a voice for lawyers. So to me, that's one of the biggest purposes of that organization, is that it represents its members who are lawyers. They also do professional development, make recommendations on legal reform. But it's really about holding the government to account from on behalf of the membership body. And that means safeguarding the rule of law. And we really thought that the CBA would be an appropriate venue because of that, right? Because we saw that we all saw what's happening in Palestine. The CBA had put statements out on what happened in Israel, but also previously it had made statements and had put out messages about other international issues where rule of law was in some way engaged. So we thought it would be appropriate, particularly given the International Court of Justice and what the decisions that had been coming out. We were waiting at first to see whether the CBA would say anything. And when they didn't, we thought that was a pretty big oversight, and thought that we should bring a resolution forward asking them to make a statement on what's going on in Gaza.
So you and I are speaking in early June 2025, but you began this journey of trying to get such a statement made a little over 6 months ago. Uh, could you tell us how the process unfolded, what you did in December of last year, and the kind of response you received?
Yeah, certainly. So there were a group of us lawyers in British Columbia who were, engaging in advocacy sometimes in different ways, or we were pro-Palestine lawyers who were essentially trying to figure out how we could help and what we could do, sitting over here on this side of the country. And we really felt that there needed to be some sort of statement made on behalf of the profession. And we decided to draft a resolution. So we worked quite hard actually on the resolution. We wanted to make sure that we really stripped it down to the facts. So we spoke about, CBA making statements on other subjects in international law. We spoke about how the president of the CBA at the time in October and November 2023 had condemned the attack by Hamas and had cited respect for the rule of law. And then also a few months later, in January 2024, when the ICJ, of course, released that ruling that Israel was in plausible breach of the Convention on the Prevention and Punishment of the Crime of Genocide in relation to Palestinians. And, so just we had kind of outlined the what the ICJ had said, the advisory opinions. We also put a note in about the Palestinian Bar Association because they had issued a statement that its headquarters in Gaza were destroyed. And so, just given the fact that Israel's actions had resulted in tens of thousands of deaths and injuries and trauma, and the fact that CBA hadn't made any sort of statement on that fact, we just asked for a resolution that the CBA would issue a statement advocating for compliance with the ICJ's ruling. And like I said, we had multiple people working on this resolution. We were changing it, we were adding things, we were taking things out because we really wanted to present a resolution, regardless of our own opinions. We wanted to present a resolution that most people could get behind. Most people could say, well, this is an ICJ ruling, and Canada should abide by it. And so we didn't want to make it controversial. We wanted to just put it down. We just wanted to lay out the facts and ask the CBA to make a statement. And so that's what we did. We sent it in. And from our understanding, the policy committee would screen it. They have a special policy committee that deals with matters of advocacy and policy. And once it went through to screening, it would be heard at the annual general meeting in February.
I wanted to return to one of your points, and it also relates to an earlier guest we had, Emilio Dabed, talking about Canadian government responsibilities under international law. And here we're talking about legal obligations, not just moral requirements. And you were making the argument as well that Canada as a state has legal obligations to act in certain ways. What happened when you made these arguments and made the proposal? What kind of reaction did you get from the Canadian Bar Association?
Yeah, so it was interesting because before we even received a response from the Canadian Bar Association, we saw the list of resolutions that were out. And our resolution wasn't there. And some people had thought that this would happen. I had remained cautiously optimistic. I wasn't sure whether the resolution would be voted in, but I didn't think that we would be stopped from even having it considered. That was a surprise to me. And so that's exactly what happened. So on January the 10th, the executive director of advocacy let us know that they rejected the resolution because it pertained to international matters outside of Canada that didn't directly impact Canadian legal professionals. And the second reason they gave was that it lacked necessary endorsement or substantial support from a CBA section or a committee.
How would you respond to those two arguments?
Well, we were a little bit frustrated, given the fact that the CBA had previously made comments on lawyers in Tanzania. I might have mentioned, about the Olympics committee. And so we had seen them make statements on that. And secondly, we didn't know there was a requirement for CBA section. And a section is essentially a group, a practice group. For instance, there's the immigration law section. And then there's also committees such as the Equity and Diversity Committee. And so we didn't realize that we needed support and their support, and there was nothing in the bylaws that said we did. Further, we were surprised that it was rejected outright because certainly there's provisions in the bylaws for the policy committee to send the resolution to a a section or committee in order to rework it or to send it for further consideration or send it back to us to revise it. And none of that happened. They just rejected it outright. So it was surprising to me.
So it was rejected outright. In one case, for reasons that you were able to show were inconsistent with other decisions that had been taken on other issues. And you gave the example of the lawyers in Tanzania. But it's also, they were saying you didn't follow the process, but you read the carefully, your lawyers, all of you. I'm sure you checked every hyphen, every comma, whatever, with that eagle eye. And there was nothing that said you had to do so. So how did they justify saying there was a requirement which did not appear in writing anywhere?
Yeah, I mean, in short, they didn't. So this was just the reasoning that was given to us. And so, of course, we started preparing a letter to ask them to reconsider. And we also started looking for section support, and we did get support from one section. But in the course of that, I had reached out to one of the committees, the Equity and Diversity Committee that I mentioned, to ask if they would be willing to support the motion, because there was an opportunity to amend the motion or to submit a late resolution, and that was in their bylaws. So we thought that that might be a way to, amend the bylaw so that it fit or essentially that we address the concerns that were brought to us by the policy committee. And in the course of reaching out to the Equity and Diversity Committee, instead of getting a response from them, I got a response from the director of advocacy, who had initially told us that our resolution was rejected, and so he gave us a new rationale, which was essentially that the resolution addressed matters that were under basically that the matter that we were addressing in the resolution was the subject of ongoing court proceedings, and that the CBA does not comment on matters such as those.
Towards the end of the interview, I want to review some of the key arguments they made, and because that's at the crux of this. They claim some things, and you're saying, well, wait a sec, that's either not in the regulations or past, there's precedent for doing exactly what they say you cannot do. But what I want to ask you for the new explanation they gave, that saying it's because there's ongoing court proceedings. What is your reaction to that claim?
We were a bit frustrated that that was a new rationale that wasn't really given to us when our resolution was rejected. So in a sense, it felt like shifting goalposts, where we just weren't really told the real reasons, or that it just felt that we were being obstructed. But because we did get that new rationale, we decided that we would include that in our request for reconsideration and a request for amendment. So in our letter of reconsideration, and of course we submit this reconsideration thinking that, well, here's us addressing all the concerns, and if you're giving us concerns and we address them, then there would be no reason not to have the resolution heard at the CBA. So we let them know that the resolution concerned Canada's international obligations, under, that it owes, and that it directly impacts Canadian legal professionals who are working in international law. And then we also highlighted previous CBA resolutions that addressed that subject. So, there was one resolution on LGBTQ plus rights in Cameroon. We cited one about, as I mentioned before, the human rights monitoring for the Olympics. And we also let them know that the CBA has a separate advocacy policy, and it expressly allows for resolutions on international matters if it's supported by a CBA resolution. So clearly, the CBA's own policy allowed for resolutions on international matters. That was the implication there. And then we also reference resolutions that were speaking to matters that were before the Canadian courts at the time the resolution was passed to address that new concern that we just spoke about. And then we also cited examples of past resolutions that did gain policy committee approval without endorsements from CBA sections and committees. And then we also offered to amend our resolution to include the section support that we had recently obtained. And so we did request a reconsideration, and if it wasn't granted, we asked to overrule the policy, do a request essentially at the AGM to overrule the policy committee's decision through a membership vote, and that was specifically allowed in their regulations and their bylaws.
Before we get to the annual general meeting, what was their response when you asked for reconsideration about the substance? You had shown that the claims they made were not valid because they weren't consistent with past practice or actual regulations that the CBA follows. How did they do? It's a bit embarrassing for somebody in an organization when they make a claim and then you come back and say, well, wait a second, look at this, we have the evidence, it's right in front of you that what you say is false. Did they acknowledge that they were at least incorrect, or did they just ignore your arguments on that basis?
We've never received an admission from the CBA about whether their decision was incorrect or whether they were complying with their bylaws. And instead, the director of advocacy had a phone conversation with the two individuals who had moved the resolution. And they were essentially told that the resolution was unconstructive for the AGM, that it was too divisive for the AGM. There was no reference to any of the bylaws or anything like that. They were just told that, this issue had been costing them too many resources and that they had other work that needed to be done. And that's what they were told. And at the time, one of the lawyers let him know that, I'm Palestinian and this is discrimination. But unfortunately, even that point, I don't think it really resulted in a resolution to what would happen moving forward.
When they talk about being divisive, it's you who is trying to bring forward a motion in response to immense crimes that are occurring. You're the ones who are divisive, not those who support those crimes or wish to suppress discussion and critique of those crimes. It tends to me to suggest something about the CBA's own political positions when you are deemed to be the problem, not those who support the genocide. They're not deemed to be the problem. Those who oppose it are seen to be causing divisiveness within the organization. Do you have any thoughts about that, or is that is that too treacherous a road to go down?
No, certainly it was disappointing because, as I said, it's a group of us. We all have our opinions about what's going on, what should happen. But we came to a resolution, like I said again, and I've detailed what it contains for you. We came to a resolution that was based on facts. And because the CBA is, they call themselves the guardians of the rule of law. Mm-hmm. So because the CBA, that's one of its purposes, I never imagined that we would get to that point. And secondly, it's important to have debate about this. It's important to talk about this issue. We're not going to get anywhere by just silencing people who disagree with us, no matter what side they're on. And I find that in my own personal life, I've really been able to talk through some of these concerns with people, concerns with people who were Israel supporters. And that's what we were hoping for was a constructive a constructive discussion. It could have been painful. It certainly could have. There's emotions, on both sides. And like I said, I've seen that in my personal life as well. But we need to have the debate.
And it's also interesting to me when you emphasize the CBA's apparent devotion to the rule of law, and yet a common critique has been the utter blatant failure of the rule of law as Israel practices impunity. So the CBA, it sounds like to me, is not really, in this case, concerned too much about the rule of law. So the next step, the annual general meeting. What happened there? Did it all work out great?
Yeah, so I should just note that during that meeting, the two movers of the resolution had asked for a final decision in writing. And so this new letter that we received a few days before the annual general meeting had it essentially just reiterated the prior reasoning, but also introduced concerns about exacerbating divisions within the membership. So now we had that was their new justification. And during the phone call, we were also we were discouraged from bringing it as a late resolution. So we were actively told that it wouldn't be welcome. So then sorry, go ahead, Bill.
But I understood there were provisions for submitting late resolutions, no? Why then would it not be welcome if it's already allowed for in the bylaws?
I think exactly for the reasons that you had mentioned before, is that there was certainly a distaste for this resolution being debated or coming forward. And that became quite clear. I mean, we suspected that was the case, but it really became clear when we had that conversation with the advocacy director, and then receiving the email that gave us a final decision as to whether or not the policy committee would allow the resolution to be heard.
It was heard though, or what then transpired?
Yes, absolutely. It was heard. So we had tried to, well, I should say that at the outset of the meeting, we were told that no resolutions would be permitted to be brought from the floor. So that was already essentially just publicized to the entire membership at the beginning of the meeting. They went through their regular matters, although they did not get an official vote on whether the agenda should be approved. And of course, our resolution was not in the agenda, but that was something that was just never approved, and it was required to be approved for the bylaws. And so that was, it wasn't the biggest issue by far, but it really set the stage for just non-compliance with the bylaws and the regulations that we observed during the rest of the meeting. And we were also, so as that happened, I reached out and I let them know that we had this resolution. And you'll remember that what we were trying to do was to overrule the policy committee's decision by having the membership vote to overrule it. And so when I tried to do that, I was told, well, late resolutions are not permitted. That resolutions from the floor aren't permitted. And so I told them, well, I'd like to submit this late resolution and like to overrule the policy committee's decision. And they were told, I was told that I couldn't do that. And then I had to cite the bylaw. And that's when they conceded that I would be able to raise it. So it was definitely something that we had to push for. Another member had also asked them to report out on the resolutions that they had rejected, which is also a requirement under their rules and regulations, and that never happened either. So we actually don't know what other resolutions were rejected. And that was something that the policy committee had to, was supposed to report out. And after that, we went into the debate portion, and it was the chair of the policy committee. So the person who actually makes the decisions on the resolutions, she's the one who chaired that portion of the debate.
My reaction is immediately, I think there's a conflict of interest there, but perhaps not. I'll let you go on.
I wouldn't go, I wouldn't go so far as to just say that that was certainly that was definitely and conclusively a conflict, but certainly, there is a bit of an apprehension of bias when you have the person who makes the decisions also chairing the part of the meeting when someone might be raising a late resolution that the policy committee rejected. And they're presiding over the debate of whether or not they should overturn their own decision or their own committee's decision. And that certainly seems quite odd to me.
So where did this end? Did you seek any remedies from the CBA?
Well, so I guess in terms of what happened at the CBA, it was, or that section of the debate is that and this might be, I've been told they had a certified parliamentarian who was available to them, so that they were consulting with. So I'm certain whether this person was informed about our resolution beforehand. And to be fair to the chair of the committee, I'm not sure whether she was told that we were trying to raise a resolution. So she actually closed the meeting without having our resolution heard, and then had to scramble a little bit and open it up again. And so prior to, before opening it up or before allowing me to speak, she essentially explained the policy committee's decision and said that it was too divisive, that it was going to cause members of it was going to cause the members of the CBA to feel alienated, that there wasn't any due diligence. And that's really why the policy committee had rejected the resolution. And so this is the sort of language that she was using to speak about this resolution. And when I had a chance to speak to the resolution, I essentially, first of all, I guess I wanted the membership to see the resolution, and I was told that that wasn't permitted. I had said, well, people should know what they're voting for, and I was told that it's not about the resolution, but it's about it's about just voting down the decision or upholding the decision. So I wasn't allowed to speak to what I would consider the merits, but the content of the resolution itself. So I essentially had to just speak to what she had said about the fact that it was unconstructive and divisive, and I had to say, we need to be able to have these discussions as lawyers, and this isn't the first time that we've had a resolution that has caused spirited disagreement. And that we had actually tried to, the concern about due diligence just was unfounded, because we had been trying to engage with the policy committee. The policy committee had that option to send it back to us or have it sent to a committee, and they just didn't. They refused to do that. So I could only really speak to, or I was only permitted to speak to that. I had. There were, so once I put that forward, I think supporters of the decision were allowed to speak, and they essentially said that, the policy committee made a decision. They raised concerns again about due diligence. Someone mentioned anti-Semitism and the fact that it's rampant, and how could we bring a resolution on this subject at this moment in time. And there was just essentially a lot of outrage about the fact that we had first, I said, I think brought the resolution at all. And secondly, that we were raising it at this late stage, despite the fact that we had been trying to raise it earlier than that. And so the person who seconded the motion, Veronica Martesius, she started to speak about her support for the resolution and started saying that, you know, it does impact the legal profession. I have had friends and colleagues who have faced disciplinary action. Veronica was unceremoniously cut off.
Who was she cut off by? The crowd or the audience or by the chair?
I believe it was either the chair or somebody from the CBA. And I should note that Veronica was the sole Indigenous participant or speaker for our resolution who was able to speak. And despite the fact that the people who disagreed with the resolution did go into, you know, the merits, I think essentially calling it anti-Semitic in a way was going into the content, but they were allowed to speak. Whereas she was cut off. It was quite, you know, it was actually that's what I found quite shocking.
I also find it curious the claim, if it was the chair, I forget exactly who you said about, oh, it's controversial. You used another word like divisive, and I assume the CBA prides itself on being democratic and representing all its members. But that argument could be used to say, let's not have any elections anymore. You know, elections are controversial, they're divisive. I mean, if by that we mean people have different points of view and they argue about them. It strikes me as profoundly anti-democratic the justification they gave to try and stop you from bringing this forward.
Oh, absolutely. And, you know, this isn't the first time resolutions do get voted down all the time. Resolutions do inspire quite a bit of debate. People agree or disagree with them, and that's the purpose. So to bring it forward and say that it's inappropriate, particularly when they're not allowing us to show the membership the text of the resolution, I felt like it was misrepresenting what we were trying to do. And of course, you know, in my response, I did tell them that, of course, you know, I take anti-Semitism very seriously and all forms of hate very seriously, but it's, and to be fair, I did take that opportunity to assure the membership that this is just about the ICJ judgment. This isn't, you know, that's exactly what it's about. Just because at that point, like I said, I was a little bit concerned that because the membership didn't know what was in the resolution and the way that it was being characterized, that people would think that there was something in there that wasn't in there at all.
Can I ask you, and I think it's probably time to wrap up somewhat, and I think I'd mentioned we would come back to summarizing the issues, but I think you have already done that very clearly. What are the next steps for you and your colleagues who brought this forward? You've been involved in fighting this for 7 months, roughly, and a frustrating 7 months it must have been given uh, the dubious rationales that were given to you, misrepresenting what bylaws said, the efforts to silence. It's quite ironic to silence lawyers who, I mean, you study how to make arguments, how to build cases, how to promote a cause, and then for lawyers to say, "Oh, we can't do that; it'll upset us," is quite striking to me. But what do you do next around this?
Yeah, certainly. You know, I guess one final note on my thoughts around the AGM was just how surprised I was by the reaction. And I've done a lot of advocacy for a lot of different issues. I have a long background in nonprofits, and volunteering and advocacy. But I've never felt silence before. This is the first time I can say in my life that I felt silenced.
Hmm.
I felt like I was being shut down and that my opinion, whatever it was, wasn't welcome. and that fundamentally I was unreasonable for even bringing it up.
Did you react to the implication of anti-Semitism uh, underpinning this resolution?
I mean, certainly I think that for myself, and it's a little bit different for myself because I don't take the word anti-Semitism very seriously when it's directed at me anymore. My husband is Jewish. I have Jewish family members and friends, and I mean, I know I'm not an I know I'm not an anti-Semite in the pure form of what anti-Semitism is supposed to be. And I am concerned about anti-Semitism. I really am. And it's been going on outside of the issue of Palestine. That's what I'm concerned about. I'm concerned about white supremacy and anti-Semitism. But so for that reason, I don't think it really struck me as much. But it did. I'll just say I was quite disappointed
Mm.
and a little bit frustrated that I couldn't talk about this resolution that we were so intentional with it and we thought about it so much. And it was frustrating to me that it was being misrepresented.
I don't know if you can speak about this, but did any people who may have supported the motion, either the details of it or the intent or the purpose of it, were they afraid at all to be seen supporting it? Is that within the CBA? We've heard many cases with teachers, with medical personnel, and others who have spoken, uh, revealing and critiquing the crimes being committed against innocent people, fearing for their jobs, their livelihoods, the well-being of their families. Is that something others may feel when it comes to speaking up within the legal profession?
Oh, absolutely. And I mean, um, many of the people in the group of drafters were extremely apprehensive about being included in this complaint because there are serious repercussions, whether through your employer or just through for instance, being part of them at the CBA or being part of other professional organizations. There's a deep fear within this profession about any repercussion, and I almost wonder, it is that fear that stops a lot of people from calling a spade,
Mm.
right? And so, like I said, we've seen that. We've even seen that within our own groups. Within our own group of individual lawyers who've been drafting this, where some people are happy to help behind the scenes, but they don't want to be public about what happened. They don't want to be part of the complaint. So it's been incredibly, incredibly challenging. But at the same time, I just received so many messages of support from people who were from the membership itself, who were just outraged at what had happened and just couldn't believe the conduct of the CBA. And that was pretty heartening, actually.
And just as time winds down, any final thoughts? Anything else you'd like to bring to viewers' attention before we close down?
Certainly just to say that, we're not giving up. We're evaluating our legal options and other options, and really what we're looking for is some reform to the CBA, where these resolutions from minority groups, particularly resolutions around Palestine, there needs to be a due process. These need to be considered in a transparent way, and they need to be debated. If the CBA is willing to do that, it'll only improve its functions as an organization that supports the rule of law. So just to say that, we'll continue, and this year we'll be bringing another resolution, and we'll see how that goes. But we're pretty motivated to continue engaging with this issue.
So that's great. Thank you. And I wish you sumud. I mispronounce every word in Arabic, just perseverance with this because it does make a difference over time. One thing, and just to remind people viewing this, that we will put up some of the documents that you've referred to on the YouTube section, so, as if, like me, they would like to read the entire let's say resolution to get the nuances of it and whatnot. That will be available for people. So thank you, and a note of admiration for you and your colleagues for taking this up and pushing it and pushing it. So often it's these steps of different groups, individuals in their workplace and in their community that fight a battle where they meet so much resistance, but ultimately it will make changes here. And I do think our resistance here is very important to support the resistance in Palestine against the genocide. So thank you very much, Samrah.
Thank you so much, Bill.
Okay, take care.